Tati Westbrooks' lawyer, Saltzy, is laying down the law, literally, in the latest filing. He's come in the most fast and furious way, like an action movie star, rushing in to save the day, answering all of our issues over the last few months in one filing. At least it's how it looks. I know I'm going overboard, but that's how it looks. Saltzy starts off saying, before defendants even filed an answer admitting or denying any allegation in the complaint, KJP and Brown are seeking a blanket order that Brown and his law firm can't be disqualified. He goes on further down to state that this is inappropriate. How can a lawyer tell everybody, I'm never going to mess up and I'll never need to be disqualified? He also says there's no other case out there where anything like this has ever been done, throwing more shade and some questions toward Brown. Saltzy finally brings the jurisdictional argument back in front of everyone. He's basically saying that because of something that's happened, jurisdiction should be given to this court to hear this case. I think I agree with him too. I wonder if the judge will. Before I go on to that, somebody in my comments section on my last video asked me why I don't censor Lori's last name. And the reason is other YouTubers haven't done that. Some that get way more views than I do. He says these are the reasons why jurisdiction should happen. 1, it shows that KJP misrepresented the nature and scope of the contacts in Washington, Lorianne, when she filed her declarations. So he is stating that KJP lied about how much she talked to Lori and how familiar she was with Lori. This is backed up by those clips I've played for you where she calls her a best friend, a watchdog, an attack dog, whatever it was, right? Though he comes in with number 2, he says that because she did this, it establishes they have a sufficient minimum contact with Washington for the court to exercise jurisdiction over them. It's almost amazing we finally have jurisdiction brought up for the first time in months on all these other filings. For anyone that doesn't understand why that's weird, it's because if jurisdiction isn't given to this court, this entire case goes away. It's all thrown out. So all those other filings would have been worthless. You'd think this would be handled first. It's nice to see Saltzy bring this up. He further elaborates, saying, it appears the correspondence between Lorianne and KJP's attorney Brown, over 150 emails and 2 telephone calls, a reasonable person would have a belief that an attorney-client relationship existed due to this conversation. To sum up the next part that I do think is worth hearing about, it essentially just says they haven't even gotten discovery yet. Discovery would allow them to subpoena communications. That way they know what's been deleted, what's been hidden, what's been erased, accounts have been closed. They can get these records just by submitting a request from the court. And that hasn't happened yet. And it needs to, is what he's saying. It needs to, so that neither the court nor the council can fully evaluate the relationship between Brown and Lorianne without that information. Saltzy stated all of this to lead up to this next paragraph. It says there is no question that Mr. Brown now has a conflict of interest regarding Lori. The record reveals Brown has repeatedly attempted to discredit Lorianne's testimony, truthfulness, and mental competency, despite his own effort to use Lorianne for her testimony on behalf of KJP. He underlines this to make a point as recently as 2 days before the signed Lorianne declaration was filed. Finally, defendant's motion to qualify relies on hearsay evidence. 1, Mr. Brown's correspondence with Lorianne, and 2, Mr. Brown's correspondence with purported relatives of Lorianne. Saltzy comes in with a 1-2 jab and says in light of these issues, they are not in a position to stipulate Brown's request to retroactively remedy the conflict of interest with Lorianne. For the same reason, the court should deny the defendant's motion. Emily Baker was very quick and smart to point out in the footnotes here, plaintiffs identified at least 2 emails between Brown and Lori that have not been filed by Brown. So why? I wonder what they say. It's crazy, right? Saltzy makes sure to include this. We will be filing an objection today, and I'd like to include a statement from you if you're on board with that. I'd like to stand up for you by filing your declaration if you'd let me. We're filing something today that addresses the threat Saltzy recently made to you. It would be great if you would state that you took it as a threat and felt intimidated, etc. This looks really bad for Brown. We saw this in the last filing, but it looks horrible. It's like he's trying to create the narrative that Saltzy threatened Lori-Ann, trying to instill in her that she should be scared. And he did this in emails. That being right below, this stating that certain emails were not included, alludes to people. They need discovery. And in order to have that, they need jurisdiction. Do you see how smart Saltzy is playing it this way? It's almost like he just took everything Brown handed him and flipped it to guarantee jurisdiction. You can roll back in my videos where I was reacting earlier on, and I stated that Brown behaving like he is and filing what he's filing almost tells the judge that jurisdiction needs to happen, because in order for the judge to do anything about what Brown was asking for, the judge would need jurisdiction. And Saltzy noticed that and made the master play. It almost seems like, unless there's some law, some rule, something we don't know about, it almost seems like jurisdiction is guaranteed. Saltzy is coming in hot now. Follow me on this one. I really think he's making a power play that I just don't understand yet. Hopefully I'll understand it by the end of the video. I've read this several times. Brown and Lori-Ann proceeded to exchange 150 emails and 2 short phone calls over 18 days. That's a lot of time and money. None of the communications establish that Brown advised Lori-Ann in writing that he did not represent her or that he was not providing her legal advice. You see this even in YouTube videos. Emily Baker, Nate the lawyer, they say this is not legal advice even in a damn YouTube video. And this dude didn't even state it here. It's almost like he wanted to represent her. The nature of approximately 150 emails that have been produced by Brown reveal that he provided Lori-Ann with legal advice relating to one, alleged harassment, not harassment, alleged harassment claimed that she received on Twitter following the filing of the declaration, and how she should respond to the plaintiff's proposed subpoena, and 3, proposed testimony in support of defendant's motion to dismiss in the matter. Primary reason Lori-Ann contacted Brown was to solicit his services to correct the record as to her employment. Saltzy goes on to say that even Lori-Ann testified Brown offered to represent her as a third-party witness in the litigation. He goes on further to show Brown telling her or advising her on what to do. Brown also dissuaded Lori-Ann from contacting plaintiff's counsel directly. For example, Brown wrote, "I spoke with Saltzy today. They are planning to subpoena your Twitter account because they see that you closed your account and they think there might be evidence there about your connection to Katie. I did not disclose that you and I are in touch. Saltzy even complained to me that you threatened him via DMs." Lori-Ann responded with, "What are your thoughts?" Brown responded, "I'll have to think about this. For the time being, it's best for you not to make any contact with Katie and vice versa." This explains, in my opinion, that Brown told Katie the same thing. So she got up on stream and switched the way that she talked about Lori-Ann. I think we know why. They are working hard to try to paint you two as a team, and that's not good for either of you. That sounds like legal advice to me. I'm just a layman though. I don't know. Lori-Ann responded, "Maybe it would be easier if I went and met with Saltzy myself. He can see me face to face and see that I'm no threat and I have nothing to hide. I actually present myself very well. I know how to be professional when I need to be. Don't worry. I will not say nor do anything without telling you first." Brown wrote back, "I understand that impulse, but you need to understand the type of person he is. This is important, okay?" He tells Lori-Ann, "Understand the type of person Saltzy is. Do you have the ability to pay for your own lawyer to help you if they do issue a subpoena?" It is unclear if Lori-Ann responded to the above email, as the record is devoid of such a response. In something I find kind of damning to the argument, Brown responded to Lori saying, "You really have nothing to worry about with this. You've done nothing wrong. I think I can help you with the response for no charge. It's very simple. To me, this establishes that relationship. At least it looks like it does." Saltzy then casts doubt on Brown and giving all of the emails and communication to the court, and further leads to the thought that they need discovery, which would mean they need jurisdiction, when he states, "It's unclear whether all of Brown's communications with Lori have been provided." One thing that I think really helps Saltzy's arguments is that he's constantly providing local laws, civil rules, federal rules for evidence, He's constantly throwing this in, like when he files the motion to strike, or responds to it, I'm sorry. Though, it's almost like he wants Brown to stay right where he's at. He says although potential conflict of interest and ethical issues plainly exist, disqualification is not yet ripe. And what he's saying is, these things aren't on my side. They're not on Saltzy's side. These things are on the other side due to the evidence in this filing. He goes on, attorneys practicing in the Western District of Washington must abide by the rules of professional conduct as promulgated and interpreted by the Washington Supreme Court. The court retains responsibility for controlling the conduct of lawyers practicing before it. He goes on to even list more legal things. Mr. Brown qualification or disqualification, probably should say for, is not ripe. Disqualify, it must be filed with reasonable promptness after a party discovers the basis for an alleged conflict. Failure to do so may result in a waiver of the objecting party and their ability to bring the motion, basically saying it has to happen right when it happens. Then he says, it doesn't need to happen yet though, because we don't have all the information. It's not ripe. He uses the word ripe here to describe it. And then he comes in with the banger. Therefore, the disqualification issue is not yet ripe for consideration. In addition, even if the issue was ready, a delay of less than 3 months while discovery has been stayed, no substantive motion practice has occurred or can occur until the court's rules on the pending motion to dismiss. And as he finishes this line of thinking, he straight out says it. Brown and Lori-Ann appear to have formed the attorney-client relationship. He explains why, but I'll just sum it up for you later. As a whole, it appears to support Lori-Ann's reasonable belief that Mr. Brown represented her. For example, the available correspondence shows that Lori-Ann repeatedly requested Brown's legal advice, and as early as December, told Brown that she would not say or do anything without telling him. Brown repeatedly offered Lori-Ann legal advice. Brown actively dissuaded Lori-Ann from contacting the counsel directly. Lori-Ann indicated to Brown on at least 4 occasions she was inclined to contact the counsel directly. However, Brown convinced Lori-Ann not to do so. And then bringing up that it's not ready to file a disqualification against Brown yet, he states that it is coming. At least it seems like that. Let me read it to you. The record reflects a significant conflict of interest. While plaintiffs have not yet moved to disqualify Brown and his law firm due to the disqualification issue not being ripe or ready, it is apparent that a conflict of interest exists such that defendant's motion to qualify must be denied. So at the end of this filing, Saltzy has taken the nuclear fire of his last filing and it's turned into the nuclear winter. And KJP is standing out there, shivering, dealing with the fallout. What's going to happen next, though? I don't know. It's hard to tell. Maybe Emily Baker, Nate the lawyer, Uncivil Law can help people understand what may come. But here, the only thing I'll say, it seems like Saltzy just drove off in his high-speed vehicle in a fast and furious nature. You'll have to excuse my dumb jokes. Like, subscribe, share, join the channel, or not, it's up to you. Either way, thank you for watching. Ring the bell though, it really helps, and I'll see you in the next one.